Okay, you're going to be taking a deposition of another party or a witness in your lawsuit. In our brief time together today, I'm going to help you understand some of the basic guidelines and remove some of the mystery involved with the deposition process. My name is Roy Comer. I'm an attorney with admittedly modest trial skills, but I do know quite a bit about taking and defending depositions. In our brief time together today, I'm going to focus primarily on very broad brush and the general guidelines, and I have provided some written materials for you. For this walkthrough, I will be asking and answering 5 basic questions that you will want to ask yourself before you take the deposition. So, let's get to work. Question number 1. Why should I even take this deposition? There are 4 main reasons to take a deposition. Reason number 1 is to obviously learn the facts that witness has. That witness will have important information that you need to evaluate the facts and circumstances of your lawsuit. And the deposition gives you an opportunity to ask some detailed questions and find out more about that information than you could by simply asking written questions. You want to avoid surprise by uncovering facts that might hurt your case. Reason number 2 is to evaluate the credibility of that witness. There is no substitute for a face-to-face encounter with the witness so that you can evaluate how you think that witness will come across to a judge or a jury. Reason number 3 is to commit the witness to a particular version of the facts. If the testimony of the witness at trial is different than what was given during the deposition transcript can be used to discredit the witness by showing the judge or jury what the witness said under oath during the deposition and arguing that the witness cannot be trusted because that witness has given 2 different versions of the same facts without a good explanation. Reason number 4 is to preserve the testimony of someone that might not be available to be at the actual trial because of age, infirmity, or distance from the courthouse. The second question you want to ask yourself is, how do I get ready to take the deposition? In my opinion, there are 6 basic steps. The first step is to review the complaint and the answer that started the whole litigation. You want to understand the basic positions that the parties have taken before you start asking any witness any questions about that. The second step is for you to review the law that applies to the events and circumstances that form the basis of your lawsuit. I know you're not a lawyer, and as daunting as it may seem, it's very important for you to understand the law that is on your side and the law that is not on your side. In California, the law that is given to the jury by the judge in trial is called jury instructions. These instructions are found in the California Approved Civil Instructions, abbreviated CACI and pronounced CACI. These instructions are broken down by category of case. So if you have an automobile accident or a breach of contract case, you can find those categories and you can find those instructions on the internet. The third step is to review the responses to any written discovery from your opponent. If you have sent interrogatories or a request for production of documents, you want to look at those answers because they are under oath. The fourth step is to review all of the documents in your own possession about the event and circumstances. The fifth step is to talk to any known witnesses about the event, if they are available to you, of course. And the sixth step is to prepare an outline. The outline should cover the subjects and the questions you intend to ask the witness. The outline serves 2 purposes. It helps you remain focused on the goals you have set for yourself, and it will also help you avoid getting too nervous or flustered during the deposition. The third question you want to ask yourself is, what attitude should I bring to the deposition? Overall, I recommend you bring your curiosity. Ask yourself, what is this case all about? Remember, your goal is to learn the facts this person has that will help you prove your case and to find out the facts that might be harmful to your case. To accomplish your goal, I believe you must have a natural curiosity about the case. Ask yourself, what does this person know and how does he or she know it? You are seeking information to prove your theory of the case. Ask and answer these two questions to formulate your theory. Question number 1, why do I think I should win this case? Question number 2, what conclusion do I want the judge or jury to reach based on all the facts, both good and bad? Then, with this information in mind, you can begin to ask the questions of the witness designed to get this kind of information out on the table. Here's a helpful tip. If you are deposing a witness that you believe can hurt you, particularly the opposing party to your lawsuit, many times it is helpful to ask the witness questions about topics that support your case before you begin to ask questions that challenge that person's version of the facts. Here's the fourth question that you'll want to ask yourself. What questions should I ask at the deposition? While I would like to help you with this, there just isn't enough time in this session to give a good answer other than some basics. First of all, you might want to start by asking broad questions to learn what the witness knows about the people involved as well as the facts and circumstances surrounding the basic controversy, whether it be an automobile accident or a breach of contract or whatever else is involved in your lawsuit. An outline will help you remember what you need to cover. Once you have a broad idea of the information this witness has, remember to narrow your questions so that you can get the details necessary to build your case. Here is a very basic outline. Start by asking some basic background questions about the witness. Do not, however, waste a lot of time with questions about their education or employment history. Who really cares about that? Then start by asking questions to determine the basic facts the witness knows, both good and bad. This will be the vast majority of the time you spend with the witness at the deposition. Remember, don't be afraid to ask questions that might be harmful to your side in the case. This might be the most important information you learn. For instance, you need to know if this witness will say you were speeding before the crash, even though you know you weren't. Another example, you need to know if this witness is going to say that you were not hurt in the crash, even though you know you were. Then you will want to ask questions to determine just how the witness learned the facts that they are testifying about. For instance, is this witness an eyewitness? Maybe the witness wasn't actually in a position to see what he or she claims to have been seen. Did the witness hear about it later? Did the witness create any documents about that particular event? Is the witness biased? Maybe the witness is related to one of the parties or a good friend with one of the other witnesses. You need to know this. Next, ask if the witness can identify any other witnesses to the event. And then you'll want to ask if the witness can identify any documents that relate to the event. And finally, in our basic outline, you'll want to ask what opinions this witness might have about the people involved, as well as the events and circumstances that led to your lawsuit. Here's a tip. Do not be afraid to ask very basic questions during the deposition of the witness. It is very often helpful to simply use who, what, when, where, why, and how. Using those words to start the question will get the witness to explain everything within their knowledge. And here's another tip. Make sure you listen to the answers to the questions you ask. It is not uncommon for a witness to try to dodge answering the tougher questions that you ask. Be persistent and get a response to the questions that you ask. Get an answer that you can use to build your case. It is not uncommon for the answer to a question to lead to an area of inquiry that you hadn't even thought of yet. Follow up with questions on a topic that is new to you. And sometimes, to do so, the very best way to ask the next question is simply, tell me more about that. Keep asking that basic question until the witness has nothing more to say on that particular topic. The fifth question you want to ask yourself is, how can I be effective in the deposition? Cooperation and persistence are the keys. How you approach the deposition is vitally important. Do not become overly aggressive, but do not become overly timid either. Remember, you get more flies with honey than you do with vinegar. Always take the higher ground. You have a job to do, and your attitude and tone of voice will create an atmosphere where that can be done efficiently. I have some final tips for you. How you ask the questions is important. Your goal is to get the facts that you can use to build your case, or to learn the facts that might hurt you so you can deal with them by adjusting your settlement position or your trial strategy. While you may want to just have a conversation with the witness, a deposition is a different animal. You need to ask questions that seek only one fact at a time, and that way you can use those questions and answers to build your case. Ask questions that do not argue with the witness. You should not try to get the witness to agree with you by debating what happened and why. Just seek the facts from the witness. The time to argue will come soon enough. Overall, remain calm, patient, and respectful to everyone in the room at all times. Well, there's obviously a lot more we can talk about the topic of taking depositions, but we're out of time. I hope these pointers and guidelines will help you feel more confident and comfortable going into that deposition. And, of course, I wish you all success in all your endeavors.